New York stacks the deck against the defendant by making them go first in the closing arguments. So, this video is about the defense's closing arguments in the Marcy prison beating case. Here's what we're talking about today. Before we get started, here is the case in a nutshell. The trial involving three former corrections officers from Marcy Correctional Facility in New York is linked to the death of inmate Robert L. Brooks. Brooks died after being transferred to Marcy on December 9, 2024. He was handcuffed and subsequently subjected to a fatal beating, with the autopsy ruling the death a homicide due to the compression of the neck and multiple blunt impact injuries. A number of the correction officers were indicted. In February, 6 were charged with murder and other related offenses in connection with Brooks's death. One of the 6, Christopher Walrath, pleaded guilty in May to first-degree manslaughter and is serving a 15-year sentence. The status of the trial of the 3 officers are Matthew Gallagher, Nicholas Kefir, and David Kingsley. They face charges including murder and first-degree manslaughter. Closing arguments have already concluded, so that's what this video captures. The prosecution's case emphasizes body cam video evidence capturing the assault and argues that the officers worked as a gang to beat Brooks. The defense argues the clients did not deliver the fatal blows, lacked criminal intent, and acted with training in chaotic circumstances. Separately, 4 other officers have pleaded guilty in the broader case beyond these 3 in connection with Brooks's death. So, with that understanding, let's take a look at the defense closing statements. Now, the defense had to go first, which is really unfair because basically they have to anticipate what the state is going to argue and argue against it without really knowing what the state is going to argue. So it puts them at a huge disadvantage. In spite of that, all 3 lawyers do get to argue for their client, and many of them have the same sort of themes, although the evidence that they're talking about relates usually directly to their particular client. So let's get started. I'm going to provide 3 or 4 different vignettes from these closing statements without comment, and then I'm going to introduce the second one and the third one, and then I'll have some closing comments. In part 2 of the video, which will be shortly after this one, I'm going to talk about the prosecution's closing statement or closing argument and give you my thoughts on that. The leadoff argument begins for Officer Kingsley.
In the body, even in the mouth. They also told you how important it is to check for hidden weapons, drugs, or items that could be swallowed or used against officers. That's the environment these men work in every day. And that's when Officer Farina steps in. He moves in to check Mr. Brooks' mouth. Not to hurt him, but to make sure there's no hidden contraband or obstruction, and possibly to wipe away blood or pepper spray. You'll see a cloth in his hand. The district attorney wants you to believe that cloth was used to try and gag Mr. Brooks, but that's simply not true, and it's illogical. Look at the video. You'll see Farina wiping. He's performing a standard, lawful, and necessary part of the search process. Suddenly, Mr. Brooks bites down, hard, on Officer Farina's finger. He didn't hurt his finger by punching him, as Sergeant Trombley tried to imply. He even heard somebody say, "Got bit." And in that instant, Farina reacts. Officer Kessler describes those punches, once in the face and several others striking Mr. Brooks viciously in the throat. Violent, forceful, uncontrolled punches that nobody in that room knew were coming and impossible to stop. As quickly as it happened, it ended. It's not policy. It is excessive. It's a spontaneous reaction to sudden pain and frustration. Put in context, being bitten or exposed to blood in a state prison isn't the same as it would be out here. Officers know what that can mean, and it happens all the time. exposure to hepatitis, HIV, AIDS, or other life-changing infections is always a concern. They know the long, uncertain process that follows: testing, medication, and the waiting. That's the kind of panic that drives a reaction like this. Now, where's Officer Kingsley during all this? Right next to Officer Farina, steadying Mr. Brooks' neck and head so the search can be completed. He's not choking him. He has his fists on both sides of the head under his jaw. His fingers are not wrapped around his neck. He's not restraining him to cause pain or obstruct his airway. He's doing what officers are trained to do: control movement in close quarters, try to steady the head and open the mouth. And when Officer Farina starts throwing those punches, Kingsley releases. He shifts, adjusts, and tries to manage the chaos. At no point does he strike Mr. Brooks. He doesn't punch, he doesn't kick, he doesn't act out of anger. Nothing shows David Kingsley is taking any pleasure in what's happening. He's calm, focused, doing his job in the middle of chaos he didn't create. That's not depraved indifference. That's not malice. That's a correctional officer trying to do his job in an impossible place. They can't anticipate what might come next. Their entire focus is on the individual, on those hands, that stance and balance. That's why the sergeant plays such a critical role. The sergeant is the one who's supposed to see the whole picture, to know what's happening in every corner of that room, and to give directions when it's needed. That's how these movements are meant to function. Clear chain of command, clear control, so things like this don't happen. Let's remember what Sergeant Trombley stated to you, that he never directed anybody to assist. That when he saw Mr. Brooks in distress, he did nothing. These words came out of his mouth: "It's not my job to remove shackles." Yet, he sat there and tried to convince you that he is sorry for what he did, while trying to blame everybody else. They worked to save him. They performed life-saving measures for minutes on end. This was not some sort of ruse to cover up these actions. And as the testimony showed, Kingsley was the first one in line to provide CPR. You heard a lot about the body cameras in this trial. The district attorney wants you to believe that these officers, including David Kingsley, intentionally didn't turn them on because they wanted to hide what they were doing. But the evidence you actually heard tells a different story. The entire facility rarely used them. Not just these officers on this particular night. Specific to David Kingsley, however, Investigator Cornish testified that the transportation officers are required to pick up their cameras from the camera room right before taking somebody out of the facility, and then return them to their docking station immediately when they get back from the transport. That's the policy. They're not regularly issued an alternate camera when they come back. And Investigator Massot confirmed that. He told you that no alternate camera was ever provided to Kingsley after he returned from transport that day. That's not concealment or being part of some conspiracy. That's procedure.
So now we have Matthew Gallagher's attorney. He's going to get up and he's going to do some reminding of the jury about the burdens, and then he's going to get into the evidence and why it shows that Mr. Gallagher should not be held accountable.
Now, before we start talking about what the evidence shows, I want to take a moment and remind you of something very simple, something that sometimes gets lost in the noise of the courtroom. This process is not about which side has the most witnesses or the most exhibits or takes the longest to present their case. This case is also not about who has the best graphics or whose IT people could put together the coolest presentations. It's not about that. It's also not about which witnesses or lawyers that you like or you dislike. or what lawyers made you laugh, or who seemed serious. And it cannot be about emotion. It cannot be about emotion, your deliberations. Emotion from the lawyers or emotion from what you feel cannot be part of your considerations. The judge will tell you that. And I know you understand that. And I know that you'll do your job because you've been as attentive as any jury that I've ever stood before. Your decisions are about the evidence. It's about proof, and it's about the government, with all its power and all its resources, has met its very heavy burden to prove Matthew Gallagher guilty beyond a reasonable doubt for 3 crimes: murder, manslaughter, and gang assault. And critical to every one of those is what was Matthew Gallagher's mental state on December 9th. The judge will explain that to you at the end. The government must prove beyond a reasonable doubt that Matthew Gallagher's intent, by any action that you see of him, was for Robert Brooks to be seriously injured or injured, and that he intended, it was Matthew Gallagher's intent to harm Robert Brooks. Within each of the jury charges you'll hear from Judge Bauer, your core consideration is this: what was Matthew Gallagher's mental state? What was his intent? Was he, by his actions, acting with what the law requires be proven, wickedness and evil? He told you he would prove Robert Brooks' death was, quote, a carefully orchestrated act, close quote. And that Matt Gallagher, quote, treated Robert Brooks with depravity. I can imagine what you expected to see. Blows raining down by Matt Gallagher on Robert Brooks as part of the, quote, orchestrated act, or a planned meeting to create an orchestrated act. And what was then shown to you by way of evidence to support that promise, that Matthew Gallagher never struck Robert Brooks, and was never shown even to try to injure Robert Brooks. Matthew Gallagher walked into a situation in the medical room at 9:24:55 p.m. that he did not create. He orchestrated nothing. All the conduct that was promised you, that they would prove to you that Matt Gallagher did, was done by others. Anzalone, Farina, Kessler, Walrat. None of it was done by Matthew Gallagher. Second, you were told in the opening that the government witnesses were to show you that Matt Gallagher was part of a gang. Remember how it was said, a gang. You heard that several times. 3 times. What gang did they show you that he was part of? Sergeant Tromley told you that these CO employees were not even friends. They don't hang out. They are co-workers. They're owned by Docs. Docs tells them how to dress. Docs tells them how to act. They're owned by Docs. They go to work in a horrible setting, and they're not buddies. They're co-workers. They're not a gang. Investigator Marticello testified that he did not know whether Matthew Gallagher was trained on the duty to intervene. Marticello showed you a training document, a use of force, but there's no signature from the trainer confirming Matt's training. He can only tell you that Matthew Gallagher signed a document that says he attended a training session on use of force, but nothing on what was taught in that. This is the government's idea from its opening of training. A 43-second clip on a 79-minute long video. The 43 seconds is the reading of the definition of duty to intervene. Doc's policy. 1 sentence. It's on a flash drive in evidence if you want to see it. It does not tell the CO what to do. And the same document states this: a staff member who observes another staff member or another law enforcement member use force that exceeds the degree of force permitted by law and or policy shall promptly report these observations to an immediate supervisor within their chain of command. What's he supposed to do? Who's he to tell at this moment when his supervisors are watching and are closer to Brooks than he, who have been in the room longer, who have more experience than he does, what's he supposed to do in terms of intervention when he knows that they're there? The government says he has a duty to intervene because there's a doc's written policy and he was trained on it. I went through that training, but I didn't go through 4944, the actual policy. It's the entire document's 16 pages long. This is the priority of doc's training of Matthew Gallagher and COs. 16 pages on force. 12 of the pages are how to write a report. 12 pages are how to fill in the blanks on reports. One sentence in this policy is on duty to intervene.
And now here is the argument for Nicholas Kefir, who also has a very minor role, just like the other two, in this particular tragedy.
Now, the death of Robert Brooks was tragic. It was brutal, it was ugly, it was unnecessary, and it was unforgivable. You know that, I know that, everybody in this courtroom knows that. The city and the county, everybody knows that. We are all deeply troubled by that. But ladies and gentlemen, you are called upon today to determine if Nicholas Kefir can be held responsible for that tragic death of Robert Brooks. Ladies and gentlemen, the issues here for Mr. Kefir are threefold. Number one, did Nick Kefir act with complete depravity for the value of human life? Number two, did Nick Kefir intend to cause a physical injury, or did he intend to cause a serious physical injury? And number three, did Nick Kefir intend to file a false instrument? To state it more clearly, more succinctly, did the prosecution meet its burden of proof to prove to you, based upon the evidence, that Nick Kefir had the required state of mind or intent to commit the crimes that he is charged with? I submit to you, and respectfully so, ladies and gentlemen, that the prosecution has failed in their burden of proof on all four of the charges filed against Mr. Kefir. As soon as they get a look at Mr. Brooks outside of the van, they can tell he's coming to Marcy because he's obviously had problems at Mohawk. His eye is discolored and swollen. He's got blood in his nostril of his nose. And you heard Sergeant say, I'll tell you, a dude doesn't hit another dude for no reason. Once out of the van, ladies and gentlemen, Officer Kessler gives Mr. Brooks another lawful directive. He tells him to carry his in-draft bags. Again, Mr. Brooks refuses and is non-compliant. Again, Officer Kessler negotiates with Mr. Brooks. I'll tell you what, I'm going to carry the heavier bag, you carry the lighter bag, let's get into the administration building. Does Mr. Kessler have to do that? Absolutely not. Again, to gain compliance. Good for Marcy. They ultimately get into the administration lobby. Mr. Brooks again refuses to carry his own property bag any further. He states, I'm not going to carry the effing bag. He was more descriptive than I. For the third time while at Marcy, Mr. Brooks is non-compliant. He is not following a lawful directive. Again, Mr. Kessler, trying to be reasonable with Mr. Brooks, tells him, look, if you don't pick up your property and you don't carry it, you're not going to have your personal property. Mr. Brooks again refuses. He says, F it, I don't want it. Did Mr. Kessler have to try to convince Mr. Brooks to carry his property? No. So again, good for Mr. Kessler. Later, on the walkway, you saw the video, you see that neither Mr. Brooks nor Mr. Kessler is carrying a property bag. So apparently that did not work out, and Mr. Brooks remained non-compliant with lawful directives given to him. They go into the Sally Port within the administration building. They ID Mr. Brooks per policy. They exit the Sally Port. They now enter into the area we've been calling the breezeway. Mr. Kessler tells the Mohawk correctional officer, the transport officer, remove the leg restraints, remove the handcuffs, remove the waist belt. The Mohawk corrections officer removes all three. Mr. Brooks is now unrestrained per Mr. Kessler. Mr. Kessler then gives Mr. Brooks another very simple, safety-based directive. Put your hands deep into your pockets. Very simple. Again, Mr. Brooks does not comply. For Nick Kefir, the prosecution has not met its burden of proof on any of the 4 charges. Let's talk about Dr. Merkulova. She did the autopsy. She told you that Mr. Brooks' death was due to compression of the neck and multiple blunt impact injuries. Multiple blunt impact injuries. That's contained right in our autopsy report that was submitted by the special prosecutor. That is Exhibit 36 for your review, if you so desire. There was no evidence presented that Mr. Kefir inflicted any blunt force injury to Mr. Brooks or caused any injury at all. None. No evidence. Dr. Merkulova closely examined the exterior body of Mr. Brooks and did not note any pepper spray on any portion of the exterior of his body. She told you that she examined his face, his eyes, his mouth, his neck, his nasal passage. No pepper spray in those areas at all. None. She also told you that she did the internal examination of Mr. Brooks' body. She looked in his mouth. She looked down his throat. Looked at his tongue. Looked at his lungs. No mention of pepper spray in any of those areas, and certainly no injury as a result of the minimum application of pepper spray.
So to summarize the arguments here, first of all, there's the issue of intent. I think everybody raises the issue of intent. They didn't intend to hurt the man. They were just trying to control him. And he had gone from being cooperative to completely uncooperative and frankly violent. Now, one of the big problems that they have, and I suspect it may have been due to an early motion in limine, is that they didn't get to bring in a traumatic brain injury expert because quite likely some of his bad behavior was due to having been beaten at the other facility that he was transferred from, and he quite likely had some kind of brain swelling that may have induced him to act out. So it is a tragedy all the way around. Will these arguments prevail? I don't know. But I do know this is a terrible, tragic case, and we'll have to see here in a second what the prosecution says about all this, because that too is important. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke. Get them a cup of coffee. Anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.